I'm Drew Stevenson, and this is a lecture for my statutory interpretation and regulation class, or Leg-Reg, about the case Cipollone versus Liggett Group, a US Supreme Court case from 1992 about federal preemption of state law. And here we're specifically talking about a judge-made law or decisions by the courts, not a statute, and the Supreme Court's presumption against preemption. Now, just by way of reminder, this also is a case that comes up a lot in administrative law. We have a clause of the US Constitution that we call the Supremacy Clause. It says when there's a conflict between a federal law and a state law, that in general, this federal law is supposed to win. But it's not always clear the extent to which there's a conflict and the extent to which the preemption should apply, or how much Congress intended the federal statute to preempt the state law. So let's look at what happens in this case. Mrs. Cipollone was a lifelong smoker. This is the plaintiff in this case. Liggett Group is a tobacco company that makes cigarettes. And so she sued the tobacco company under various theories of state common law liability, and basically argued in the alternative, strict liability, negligence, failure to warn, express warranty of safety, and so forth. And most of these boil down to claims that basically cigarettes are hazardous or bad for you. And secondly, that the tobacco company knew this and deliberately misled consumers as to just how hazardous cigarettes were. And the tobacco company didn't try to say that cigarettes aren't dangerous or hazardous. Instead, they said that all of the state law claims here, all of them, were preempted by a federal statute. And that's what we're going to be talking about in this lecture. That's the focus of our video here, or why we're studying it in our class. The statute is the 1965 Cigarette Labeling and Advertising Act, which required cigarette packages to contain a health warning. And so we had a federal law that basically said that starting in 1965, that all cigarettes sold in the United States had to have a warning on the package that would be basically prescribed by the Surgeon General. And the act included an express preemption provision that said no statement related to smoking and health, other than the statement required by the federal statute, shall be required on any cigarette package. So what Congress really wanted to have was one standard warning nationwide, so that cigarettes packaged and sold to be sold in one state could be sold anywhere, and we wouldn't have to have separate packages, state-specific packages, just because some state wanted a slightly different wording on their or labeling on the package or something like that. So this was an attempt to have standardization in the warning. And then 4 years later, Congress amended the statute and strengthened the warning. So the warning was harsher, and they banned certain types of cigarette advertising. And Congress modified the preemption provision to be a little broader, and said, so it said, no requirement or prohibition based on smoking and health shall be imposed under state law with respect to advertising or promotion of any cigarette. So we're not just talking about states trying to require extra stuff on the labels or packages, but any type of requirement that certain things be stated in marketing materials and so on, as long as the cigarettes are labeled in conformity with the federal statute. In other words, as long as they're following the federal regulations, states can't add more on top of that. So this isn't what we would call an express preemption clause, not anything implied. Now, the company claimed that the plaintiff's the company asserted that the plaintiff's claims were merely assertions that the company is liable in tort because it didn't give adequate warning about the dangers of cigarettes, right? So if she's saying that if Mrs. Cipollone is saying Liggett knew they were dangerous and underplayed that in their advertising and should have warned and so forth, then and the cigarette company is held liable, that basically implies that there was a duty, and there would be a duty going forward from that case for them to have these types of labels. But the preemption provisions clearly say that states are not allowed to impose additional disclosure requirements which would be the effect of imposing tort liability. So the holding of the majority here is that the amended act did indeed preempt claims based on failure to warn and any type of neutralization of federally mandated warnings to the extent that those claims relied on omissions or inclusions in the manufacturer's advertising and promotion materials. But the court then said that the act did not preempt claims based on express warranty, intentional fraud or misrepresentation or conspiracy. In other words, they agreed that we have an express preemption clause, and so a court cannot hold a company liable in that case for not saying enough on their labels, for not warning enough, right? But if she can put on evidence that the company said things that were not true or misrepresented things, committed intentional fraud, or made some express warranties that were false, apart from the label, they could be held liable for that in spite of the preemption clause. So note that even though the statute has an express preemption clause, the court invokes the presumption against preemption, which is they also call a clear statement rule, to construe the clause narrowly and allow some claims to survive. Here's a quote in case you're looking for something to highlight in your casebook for the rule of law. The preemption applies, quote, when Congress has considered the issue of preemption and has included in the enacted legislation a provision explicitly addressing that issue. And when that provision provides a reliable indicium of congressional intent with respect to state authority. Now, we have a partial dissent here from Justice Scalia, and he agreed with the result. He thought that there should be preemption, but he didn't agree that the court was interpreting it he thought they were interpreting it too narrowly. And he basically said that the clear statement rule is incoherent because we have a doctrine, which wasn't really at issue in this case, of implied preemption. And so note, Scalia is pretty famous for his textualist approach to statutory interpretation, and a textualist approach would find preemption more easily. In other words, it would kind of take the express preemption clause and read it at face value, and therefore read it rather broadly, instead of looking at what specifically it says it preempts and then trying to allow everything else. And so now note that his view gives less deference to state laws and court. So on the one hand, even though Justice Scalia generally advocated for stronger states' rights, preemption it is not promoting states' rights, right? It's preempting state laws. But stronger preemption also is bad for plaintiffs and tort claims. And so it makes these tort lawsuits more difficult to win. Note that the majority is narrowly construing an express preemption clause, and that the effect of that in practice is it will give plaintiffs more options to sue. And that concludes our lecture about this preemption case, about federal preemption of state tort law.